Hi, this is Nick Critelli in Des Moines with today's video law brief. I predict that the City of Riverdale versus Diercs is going to become a very important case. It's a case of first impression concerning attorney fee awards in matters brought against government entities for violating the Iowa Freedom of Information Act. There's a very interesting cast of characters. A city that's been plagued with FOIA requests by a group of activists, a mayor who's at his wits' ends in trying to deal with them, a city attorney who's caught in the middle, and a junior associate who gets too far out on the limb. So here's Suzanne with today's video law brief.
City of Riverdale versus Diercs, November 18, 2011, Iowa Supreme Court. City of Riverdale versus Diercs is a case of first impression addressing the standards for awarding attorney fees for violations of the Iowa Open Meetings Statute. The case pits the Iowa Open Meetings Statute's requirement of a mandatory fee award to prevailing parties against the safe harbor for officials who in good faith litigate disclosure issues on advice of counsel. It concerns an award of over $64,000 of attorney fees against a city for failing to provide security camera recordings to two community activists. The activists had a long history of making open meeting requests to the City of Riverdale. In addition to the requests, they had engaged in 7 earlier open meeting lawsuits against the city, and in the Supreme Court opinion by Justice Waterman, were credited with making over 190 requests, accounting for over 80% of all the city's open meeting requests. The incident, which gave rise to 16 months of litigation, and the appeal arose when the activists were at a counter of the city clerk's office to pick up a document from yet another request. While at the counter, the mayor attempted to engage them in conversation in an attempt to get them to mediate their disputes with the city. The conversation got heated, with both parties lobbing accusations and insults at each other. The whole incident was caught on video by a security camera focused at the city clerk's counter. Shortly before the encounter, the city had purchased and installed a security system from Paramar Security. At that time, the city attorney had issued an opinion that videos from the camera would be subject to disclosure under Chapter 22 of the Code. Hearing about the confrontation, a reporter for the Quad City Times asked to see the video. The mayor showed the video and offered a copy to the reporter, which was refused. Then the activists made a request for the security video. The city attorney procured a copy of the video and was in the process of making it available to the activists when the mayor asked that Paramar be contacted to see if disclosure would violate any proprietary rights. Paramar replied that disclosure could compromise security. Chapter 22 provides an exception to the full disclosure mandate by protecting those items which compromise security or subject employees and others to danger. Based on this, an associate in the city attorney's office advised that the video not be disclosed, and the city institute a declaratory judgment action to determine whether the video should be disclosed. The activists counterclaimed for costs and attorney fees. The litigation was extremely contentious. Over 13 dispositions were taken, 18 witnesses testified, and 2 expert witnesses were engaged, one saying that disclosure would compromise security, the other taking the opposite position. The city hired 2 trial lawyers with over 60 years of experience, and the activists were represented by counsel with over 30 years of municipal law experience. After 3 full days of trial, the district court found that the video should have been disclosed, rejected the city's defense of advice of counsel, and awarded the activists legal fees and costs. However, the district court failed to make a specific finding as to bad faith. At the hearing on fees and costs, the city argued that because the court made no finding of bad faith, an award of fees and costs was inappropriate. The activists replied that bad faith was implied because the district court sustained their counterclaim. In its ruling on the fee application, the district court acknowledged that it did not make a specific finding of bad faith. Further, it recognized existing law to the effect that when a record custodian brings a declaratory judgment in good faith to determine whether the documents are subject to disclosure, they should not face the sanction of attorney fees, citing the 1992 Des Moines Independent School District versus the Des Moines Register and Tribune case. However, the district court went on to hold that this is one of the cases where, based on the specific facts, attorney fees for prosecuting the counterclaim should be assessed due to the violation of the Act. On appeal, the city claimed that the district court committed error in awarding attorney fees because there was no specific finding of bad faith. It further argued that the defense of advice of counsel precluded a finding of bad faith. The Supreme Court disagreed, noting that the issue of good or bad faith is always a fact question. By finding for the activists on the counterclaim, it impliedly rejected the city's good faith reasonably delay defense. Because the activists were successful parties, they are entitled to recover their reasonable fees without an express finding the city acted in bad faith. Addressing the mandatory fee award provision of the Iowa Open Meetings Statute, the Supreme Court said, "This case aptly illustrates the need for attorney fee awards to motivate private attorneys to represent citizens who are improperly denied access to public records. The defendants were forced to litigate against their home city for 16 months before obtaining the video recording of their confrontation with the mayor." Likewise, the Supreme Court recognized the safe harbor afforded public officials when they rely on advice of counsel in litigating to determine whether it is appropriate to release documents. However, it recognized that this case presents our first opportunity to clarify the standards for awarding attorney fees under Chapter 22. The court noted that because the district court found in favor of the activists on their counterclaim, there was an implied rejection of the city's good faith reasonable delay claim. The city needed to prove good faith in order to avoid a violation of the chapter and resulting obligation to pay fees, which it failed to do. Next, the Supreme Court addressed the advice of counsel defense. Advice of counsel does not automatically establish good faith, but is a factor to consider in determining whether a party acted in good or bad faith. In this regard, courts must engage in both an objective analysis of regarding whether the delay was reasonable, as well as a subjective analysis that determines whether a city had an honest motive. Based on the facts, the Supreme Court analyzed the subjective element of honest motive. It noted that the city had conflicting advice regarding whether to release the video, with the senior attorney stating that the video should be released and the junior opting for litigation. But the court was specifically concerned about the fact that the mayor played the video for the press but refused to give it to the activists. Justin Waterman said, "It is untenable for Riverdale to play the video for a reporter covering the dispute between the parties and yet withhold the same video from the defendants who requested it. It is axiomatic that disclosure to a third party waives confidentiality." Once the mayor played the video for the reporter, a claim of confidentiality was not even fairly debatable. The correct legal advice should have been to produce the video to the activists rather than litigate for 16 months. The Supreme Court declined to vacate the fee award and sent the case back to the district court to determine the amount of fees to be awarded to the activists for work on the appeal.
Thanks, Suzanne. So what's the takeaway? I really think there are three. First and foremost, be consistent. You can't disclose confidential information to the press and then turn around and refuse to disclose it to another member of the public because it's confidential. In this case, the inconsistency caused the court to question the honest motives of the city. Second, be objective. The senior city attorney was objective when he told the city to release the video. However, the junior associate was more easily swayed and influenced by the mayor. Third, remember that the litigation strategy you use can sometimes come back to bite you. In the opinion, Justice Waterman referenced that the litigation took over 16 months, not one time, but 4 times. He referenced 13 depositions, 18 witnesses, and 2 trial lawyers with over 60 years' experience. Now, why did he point this out? Remember, good faith is a subjective test, a test of one's honest motives, and one's motives are almost always judged by what they did. Apparently, Justice Waterman thought that they fought too much. Remember, the theory that underlies the Freedom of Information Act starts from the premise that information is disclosable. It was the city that brought the declaratory judgment action. Apparently, the Supreme Court inferred from the intensity of the litigation that the city didn't fully appreciate the disclosure mandate that underlies the act. Until next time, thank you for allowing us to be your ethics and conflict counsel. We at Critelli Law wish you a Merry Christmas and a Happy New Year.